Black men have been admitted to state prison on drug charges at a rate that is more than 13 times higher than white men.
The criminal justice system is systematically set up to allow the imprisonment of people of color and not allow a challenge to the courts on the basis of a systematic racial statistics.
Kleski was a black man sentenced to the death penalty for killing a white officer. He argued that he was being racially discriminated as more blacks were arrested for targets whites than whites were for targeting blacks. Statistical evidence to back up his claim. Georgia prosecutors sought the death penalty in 70% of cases involving black defendants and white victims, but only 19% of cases involving white defendants and black victims.
By a one-vote margin, the court rejected McCleskey's 14th Amendment claim of racial discrimination, insisting that unless McCleskey could prove that the prosecutor in his particular case had sought the death penalty because of racial bias, or the jury had imposed it for racial reasons, the statistical evidence is valid but did not prove unequal treatment under the law.
Statistical evidence. He could not use them to defend himself because the court doesn't see this as proof of being specifically targeted directly due to his race.
Till 1860, no black person had ever sat on a jury in the U.S. In 1880, the Supreme Court intervened, striking down a West Virginia statute that expressly reserved jury service to white men. However, even today, we still see lack of black representation in juries.
Perkett v. Elm in 1995, the Supreme Court ruled that any race-neutral reason, no matter how silly, ridiculous, or superstitious, is enough to satisfy the prosecutor's burden of showing that pattern of striking a particular racial group is not, in fact, based on race.
In other words, prosecutors can make up a number of legally acceptable reasons to exclude black people from juries through supposedly race-neutral factors such as hair length, clothing, age, political ideology, and even factors that may correlate with race and poverty, such as lack of education, living in the same neighborhood as defendant, or prior involvement with the criminal justice system.
Cases are systematically set up to allow the high rates of imprisonment of people of color, and in addition make it hard to challenge racial bias. Thanks to all-white juries, blacks are more likely to be incarcerated while whites are more likely to get off clean. In addition, even if shown through credible statistical evidence, could not be challenged under the 14th Amendment in the absence of clear evidence of conscious and discriminatory intent. These factors play into the tragedy that we call the new Jim Crow.